Kristen? Are you going to join me on video? It's okay if not. Good morning. Hey, hi. Okay. Good morning, everyone. Welcome to another edition of Get Closed, Get Paid. This is not your normal second Tuesday of the month class. This is a bonus class called Hurricane Prep for Real Estate Agents. Today's Tuesday, March 26th, 2024, and we have a topic that is different than your normal contract class, and it is still early. We're not yet in hurricane season, but this will give you a few ideas of topics to discuss in case you get questions from your clients as we go into hurricane season, whether you've got a buyer who is worried about going under contract and having the property perhaps be damaged during a hurricane, or a seller who's wanting to understand what their rights and responsibilities are with respect to maintaining the property. So today we're going to discuss those topics, but first, my name is Erin Michelle Miller. I'm a real estate attorney. If this is your first time joining us, I do real estate closings. I've got a title company and a law firm here based in Jupiter and in Naples. And my colleague is Kristen King-Javen. She does not do real estate closings. She is an attorney who represents real estate brokers and agents in all kinds of issues. Kristen, what you got for me?
Hello, everyone. Good morning. So we've got hurricane prep today. And just to do a little plug for our next meeting, we are going to redo the Buyer Broker Mastermind on April 9th. A lot of you have already taken our Buyer Broker Mastermind, but now we have huge changes to go over. So it will be a similar course, but we're going to focus on the settlement agreement that came out of the Sister Burnett case last week, and what changes are expected in July for NAR policies, MLS changes, and all that fun stuff that we've been learning about and hearing about over the last week. So that update will happen on April 9th.
Awesome. And if you haven't already registered for the Florida Realtors course, you really should register for the Florida Realtors update on Thursday, the 28th. Go to floridarealtors.org and they can walk you through that process for registering for their class. We're not affiliated with that class, but it is a good one to get updated on. Good morning, Eric. Good morning, Alyssa. Good morning, Melissa. All right, so my favorite slide I almost forgot in this presentation, but Kristen was so kind to add it for me. This is our attorney disclaimer language. Of course, this presentation is for educational purposes only, does not create an attorney-client relationship. If you have any specific questions about current legal issues that are going on in your world, let's save them for after the recorded presentation, and then we're happy to talk through them with you. And Kristen and I do serve on a number of committees with Florida Realtors and Florida Bar and local boards. The opinions that we give, of course, during our presentations are our opinions only. They don't necessarily reflect the opinions of the boards. And given the nature of our industry today, we are going to be very careful and cautious to make sure we are promoting competitive behavior. We are not going to participate in antitrust language or discussion. And all of that said, please, if you have any questions, pop them in the chat, or we can wait till the end and we can have a discussion. We can stop recording and you can ask your questions as we go. All right, let's get started. Today, we're going to talk about preparing the seller and the buyer for transactions during hurricane season, where we will talk about force majeure, FAR Standard G, extensions of the closing date if needed. We'll talk about the risk of loss, the seller's duty to maintain the property and the condition it was in on the effective date, but we've got some exceptions if there is casualty damage. We'll go through a couple of hypotheticals. We'll talk about lessons from Hurricane Ian, discuss insurance, post-storm inspections and estimates and loan closings, and then we'll go through some practice tips and answer your questions. And let's get started. So, talk about preparing the seller and the buyer for transactions during hurricane season. Really, it's more important at this moment, because we are not even in hurricane season that starts June 1st, to prepare your family first. Prepare your family now. Make sure that you've got your hurricane plan in place, but also consider documenting what you're doing now to prepare for hurricane season so that you can prepare those materials and share them with your customers, especially if you've got a customer that this is their first time, their first year spending in Florida during hurricane season. You can be a valuable resource to them. Also, make sure you're preparing your business now. Make sure you understand your board, your brokers, and your team's plans, if there are plans for evacuation, if there are responsibilities that you will have on behalf of your company to maintain the operations during and after a storm. Make sure that you've got a plan in place. There are resources through Florida Realtors that you can use as a guide to maintaining your business during hurricane season. Preparing your seller and buyer. Prepare your customers. Have a hurricane checklist, not just one specific to making sure that they're home is ready during hurricane season, but also some of the tips that you've learned as a participant in the community where you, things that are really important to you, things that you've helped you out during the few hurricanes that we've had over the last few years. Share your resources, where to find information. If you have got a particular handyman or contractor that has been there for you throughout whatever storms have come your way, of course, you can provide that contact information to your customers, and they'll be very grateful for that. Also, most importantly, be prepared to answer the what if questions. So some of those what ifs will come about during your contract, when you're under contract, but also while you're listing the property. You want to make sure that you are able to answer some of those what if questions, or at least anticipate those, and that's part of our goal today. Also, one thing that really helped during when we were going through Hurricane Ian in Southwest Florida, for each of your current transactions, create yourself a little vendor contact list to share with your customer and also your team. So you'll have the property management company, the association, closing agent, insurance agent, lender, licensed contractors, municipality information, emergency contact information, emergency hotlines, all that information. Perhaps you'll have something fancier than a spreadsheet, but we had a spreadsheet. It was very helpful to be able to look at every file and know who exactly we need to contact, because some of those vendors may not be available. They may have closed down their business during hurricane season or to prepare for the storm. And you want to make sure, again, you've got their direct contact information. Also, really important that we can manage our customers' expectations. What can the parties, the buyers and sellers, expect from the realtors in the event of a storm? Again, most of our clients can handle anything that we share with them, as long as they're appropriately managing their expectations, right? So if at the beginning of listing a property, you have a conversation with your customer and say, these are the things that could happen during hurricane season. If you need a contractor to assist you while you are up north, or putting on your hurricane shutters, for example, I can provide you with those resources. Some of your sellers may think that you will go above and beyond, not just a responsibility, but take on some additional liability on their behalf and decide to put up shutters for them. I would very strongly caution you against going beyond the scope of your responsibilities as a real estate agent, but provide resources, provide contact information for folks who can assist your customer. Again, you may be, during a storm, you may also be evacuating, you may be putting up your own storm shutters, you may be assisting your neighbors and your family members. So you want to make sure that you're doing this and providing information to your customer up front, whether you're the buyer, buyer's agent or the seller's agent, and making sure that they're aware of your plan, whether it's for evacuation or you intend to stay in town. If you are available to assist with cleanup post-storm, or checking on the property post-storm when it is ready or safe to do so. I think during the last couple of storms, at least in Southwest Florida, there were some folks who had maybe unreasonable expectations of their real estate agents and thought that the real estate agents should do more while they were also handling their own storm damage. So again, at the very beginning, especially when we're taking a listing in the next couple of months, where the property would likely sell during hurricane season, we want to make sure that we're managing those customers' expectations. And same with the buyer, right? If you intend to evacuate South Florida and you will not be around the week after the storm passes, you need to make sure that you're managing your buyer's expectations, because you won't be available to check on the property, visit the property, but you can point your customer to resources. All right, we're going to dive into the FAR and the FAR as-is contract provisions. These provisions are the exact same in both the standard FAR contract and the FAR as-is contract. We are not going to address the NABOR contract today. We'll have a future presentation comparing the force majeure provisions with the casualty provision in FAR with the casualty provisions in the NABOR contract, because they are very, very different. Both function just fine, but they are very different. And I've got some tips if you intend to use the NABOR contract during hurricane season, things to be aware of. All right, but today we're just going to talk about the force majeure provisions, paragraph 5, and standard D of the FAR contract. We'll talk about your maintenance obligation in paragraph 11, and our risk of loss provisions in standard M of the FAR. All right, so I'm focusing on paragraph 5b. It says if there's an event constituting force majeure, if it causes services essential for closing to be unavailable, or the unavailable of utilities, or issuance of hazard insurance or homeowners insurance, the closing date shall be extended as provided for in standard G. What I don't see here is language saying, and this is where we got stuck a little bit during the last hurricane season, was some attorneys read this to mean if the buyer is getting financing and homeowners insurance isn't available, then closing can be extended. But that's not what the plain language of the contract says. But just know that that was a sticking point with counsel for sellers on some of our transactions that needed to be extended, that may have been cash transactions. The buyer would love to have closed, but they were unable to bind insurance. And we'll go into that in a little bit more detail in a moment. All right, synergy force majeure. Force majeure, our definition in line 442 to 445 essentially means that neither party is going to be penalized for doing something or not doing something that they weren't able to do due to something that was out of their control, right? Whether it was an act of God, a hurricane, flood, something that neither party caused to happen. If one of the parties cannot perform due to the force majeure event, then one, there won't be any penalty, but also two, some of those deadlines will be extended until up to 7 days after the force majeure event no longer prevents performance. And so some folks will say, okay, wait a minute, how can I calculate that day, right? That day that the force majeure event no longer prevents performance. Well, it depends on what the issue is. So if your major issue is the buyer cannot bind insurance, then the end of the force majeure event is not the day after the hurricane passes. When is it? It is when hurricane or a homeowner's insurance is able to be bound when the moratorium is lifted after the storm has passed. And again, that won't be immediate right after the storm has passed. So you want to make sure that if you're going to deal with a force majeure event, you're going to define it. So identify what it is that is preventing performance. And again, in this instance, we're talking about hurricanes or maybe a pending hurricane. And what it is that's preventing a party to perform. So buyer can't bind insurance because there's a moratorium on the issuance of homeowners insurance or flood insurance policies. And so the force majeure event, we're looking at a line 446, will deem to have begun on the first day. The effect of the force majeure no longer prevents the performance, meaning no longer prevents someone from being able to obtain insurance or approvals essential for closing. Now, if the force majeure event continues to prevent performance more than 30 days after the closing date, either party can terminate the contract by delivering written notice to the other party, and then buyer will get their deposit back and both parties can go on their way. That makes sense. There's no need to keep the buyer and the seller bound into a contract when performance cannot be completed, again, due to a force majeure event through no fault of either party. These are our contract terms when we're talking about force majeure. Property maintenance. We know that our sellers have an obligation to maintain the property in the condition it was in on the effective date. That duty to maintain the property in the condition it was in on the effective date is for FARBAR standard contract and the FARBAR as is contract. Some of our sellers are surprised if they're selling the property as is. They think, well, whatever condition the property is in on the closing date, that's what the buyer gets. They're getting it as is. Let's shift our perspective just a little bit. Our buyer, even if it's an as-is contract, has the reasonable expectation that the property be delivered in the condition it was in, not as is, but as was in on the effective date, subject to, again, ordinary wear and tear. And we'll talk about casualty loss in a second, but we know that our seller has to maintain the property. So let's forget a hurricane right now, but let's say the air conditioning was working on the effective date. It breaks prior to closing. There's no hurricane. It just dies. The air conditioning just dies. The seller has to maintain the property in the condition it was in on the effective date. So the seller would have a duty to repair. And if it can't be repaired prior to closing, then escrow 125% of the estimated cost to bring that air conditioning back into working condition. Now we're going to talk about our risk of loss. So again, starting with the point that the sellers have a duty to maintain the property in the condition it was in on the effective date. However, if there's casualty damage to fire, flood, hurricane, and the cost of restoring the property exceeds 1.5% of the purchase price, then, or if it's less than, I'm sorry, than 1.5% of the purchase price, then the seller has a duty to restore the property and the parties will close the transaction. So again, hurricane damage, the estimate for the cost to repair the property, restore it in the condition it was in, and the effective date does not exceed 1.5% of the purchase price, then sellers shall restore the property at seller's expense and the parties will move forward to closing. If, however, the restoration can't be completed as of closing, then we escrow 125% of the estimated cost to complete that restoration at closing. The concern here, of course, as you can imagine, after a storm passes, things are a little bit chaotic, and you may have a hard time getting an inspector to come back out to the property after the storm passes, and you may have difficulty obtaining an estimate to be able to escrow that 125% of the estimated cost of the repair. So it is certainly okay for a buyer and a seller to agree by, I'm going to say amendment to contract. You guys will use an addendum, but I'm going to continue to say an amendment to contract to have the parties agree that a particular sum will be held in escrow at closing until the seller is able to complete that restoration. Again, our seller's obligation to restore in the event of casualty issue is up to 1.5% of the purchase price under the FireBar contract. Now, if the cost to restore the property exceeds 1.5% of the purchase price, then the seller is only obligated to pay up to 1.5% of the purchase price. But buyer could either elect to take the property as is with the 1.5%, presumably 1.5% credit, and the buyer can apply it to their own restoration, or the buyer can terminate the contract and receive return of the deposit. Again, this is managing the buyer's expectation. If the seller is only obligated to repair up to 1.5% of the purchase price, and there's extensive damage to the property that exceeds 1.5% of the purchase price, then if the buyer is thinking, you know what, this property is way too damaged, there's no way that I'm going to accept at this purchase price, this property with only 1.5% of the purchase price towards restoration, then the buyer, of course, can terminate the contract, receive a return of their deposit, and buyer and seller can go on their way. What happened during Hurricane Irma, not Ian, but Irma, was significant landscaping damage. So under the FireBar contract, the seller's obligation for dealing with tree damage is really just pruning and removing damaged tree debris. So they don't have to replace the landscaping, they just have to remove the damaged landscaping. All right. So let's go through some hypotheticals. We'll go through 3 different scenarios. One is the force majeure and the contract deadline. The other is dealing with post-storm trees and landscaping issues. And then we'll go through some hypotheticals regarding the seller's liability for repairs. All right, we've got our hypothetical dealing with force majeure. Our seller, Sally, enters into a FireBar contract to sell her condo with a closing date of September 30th, 2024. And September 28th, Betty's flying down to Florida. She's going to fly into Palm Beach International for closing, but there's a hurricane in the Atlantic and it's forecast to make landfall the following day. So all of the airports are closed, so Betty can't get into town for closing. Also, Betty's insurance company will not bind her insurance policy on the purchase because there's a hurricane in the Atlantic. So under these situations, what happens under paragraph 5 and standard G of our contract? What do we say happens? Are we going to force Betty to close the transaction without insurance on the 30th? No. Are we going to force Betty to close without being able to visit the property? Again, the transportation delay that was out of the control of Betty, our buyer. So we know under paragraph 5 in standard G, under the force majeure provisions, if there's a force majeure event, which we're defining as the hurricane or impending hurricane, Betty has the right to extend those deadlines, including the closing date, up to 7 days after the force majeure event no longer prevents performance. So specifically with the insurance binding, again, they're not going to reopen the insurance markets the day after the storm passes. It may be a few days after the storm passes before Betty's able to bind insurance again. But there is a provision, again, under standard G that will allow the extension of that closing date. So Again, availability of insurance is disrupted due to the hurricane. Closing is going to be extended to reasonable time, up to 7 days after the force majeure event no longer prevents performance. I really think it's important to identify the force majeure event in writing, right? Identify the force majeure event and identify what term of a contract the buyer or the seller is not able to fulfill as a result of that force majeure event. And that way you'll know when the force majeure event stops preventing performance, you'll be able to calculate your estimated closing date. Now, between the buyer and the seller, they can always agree on a particular closing date in the future. The problem is it's sometimes hard to predict when the insurance market's going to reopen, when the lender will be able to close the transaction if they need a reappraisal or something like that. So I would perhaps use the boilerplate language in the sales contract to extend the closing date a reasonable time, because it would hate for you to extend once, not use this language under the FARBAR contract under Standard D, extend once and then need subsequent extensions. And as we all know, it's sometimes easier to ask for one extension. It gets a little bit trickier when we're asking for multiple extensions. So I think this is handled pretty well under the contract. And again, if the force majeure event continues to prevent performance for more than 30 days beyond our original closing date, then either party can terminate the contract. So what if it has nothing to do with the buyer? Buyers are able to be in Florida. They're here in Florida. They were able to buy their insurance, but the closing agent's business is shut down due to the hurricane. Similarly, availability of insurance and closing services, if they are disrupted due to a hurricane due to the force majeure event, closing will be extended a reasonable time after force majeure no longer prevents performance. So for practical purposes, if a closing agent's office is, flooded as well, they're not able to close transactions for a period of time, closing dates shall be extended a reasonable time to be able to accommodate performance. Now, with all of the technology we have, a lot of our closing agents do have the capability to work remotely or to close from a remote location. So as happened during both Hurricane Ian and Irma, closing agents were able to get the transaction completed, though their office, was perhaps shut down. They were able to close from a separate location. This is where it's really important as you're going into storm season, ask the closing agent sort of what their plan is in the event there is a storm that affects their business, and then stay in touch with them. Make sure you've got a cell phone number for the closing agent, make sure you've got a cell phone number for the attorney who's representing your customer, and make sure that they have yours, of course, as well. All right, our landscaping issue. So Hurricane Harry passed through the area and destroyed so much of the landscaping throughout the neighborhood, including 5 of the trees on the seller's property. And one of the trees fell in the neighbor's pool cage. Okay, so this is dealing with a single-family home in a development, and there was a lot of hurricane damage for landscaping. And of course, we've got a tree falling on our neighbor's pool cage. So what is our seller Sam's responsibility for the tree damage? As we know, Standard M, risk of loss, deals with pruning or removal of the debris only. The seller does not have to replace all those beautiful trees that are within the yard of seller Sam's property prior to closing. Just remove the debris. But who will be paying for landscaping in the common areas of the association? So again, not only was were there trees damaged on seller Sam's property, but also all along the sidewalks throughout the development, there was some storm damage to those trees. You're imagining there could be a pretty hefty assessment that is going to be levied by the association to the unit owners. I put the word likely. I'm tempted to remove the word likely before likely the buyer will pay. There may be some situations under which the seller would be willing to pay, but the buyer will essentially be on the hook for any assessments that are levied after the effective date of the contract, if the storm, of course, occurs after the effective date of the contract. So again, if the storm happens prior to contract execution, we've got a different scenario, but in our specific instance, we're talking about the storm happening after the effective date of the contract, and chances are the buyer is going to be paying those future assessments that are levied after the effective date of our contract, because nobody anticipated that hurricane passing through. All right, what about the neighbor's pool cage? So seller Sam is dealing with removing the debris on his own property. He knows that the buyer is going to be handling the special assessment levied by the association after closing. just going to be the buyer's responsibility. And what about the neighbor's pool cage? So since the tree falling was due to an act of God, it's likely the neighbor's responsibility to remove the portion of the tree within the neighbor's property line, and also any insurance claim would likely fall on the neighbor's insurance policy. I'm saying likely because there could be a scenario where the neighbor has warned seller Sam, hey, your tree is dead, it's at risk of falling over, it's going to fall on my property, it's going to cause damage, and the seller Sam failed to remove it. So there could be an instance where the seller Sam could be responsible, but generally whatever's happening within the property lines of the seller is seller Sam's responsibility, and if it happens on the neighbor's property, that would typically be the neighbor's responsibility. All right, we're talking about risk of loss. Now remember how we talked about in the FAR contract, both the as-is and the standard contract, the seller has the same duties under standard M for risk of loss. The seller's obligation to make repairs to the property shall not exceed 1.5% of the purchase price. So we know that the estimated cost to repair the roof, the pool cage, and the window damage to seller Sam's property is $60,000. Let's say our purchase price is $400,000. So what are seller Sam's obligations with respect to that casualty damage under FAR? Again, our risk of loss, seller's obligated to restore at a cost of up to 1.5% of the purchase price. If it's not completed by closing, the seller has to escrow 125% of the estimated cost to complete the restoration. If the cost is over that restoration limit, then the buyer can elect, again, to accept the property in its as-is condition with a credit of 1.5% of the purchase price, or terminate and receive a return of their deposit. So if we've got a $400,000 purchase price, seller Sam is only responsible for repair costs up to $6,000. So our buyer bill can either accept the property as is with the $6,000 worth of restoration, or they can terminate the contract, again, because the damage to the property exceeded 1.5% of the purchase price. Also, we'll talk about were there any questions? Let me back up one sec. Were there any questions about our hypotheticals? I feel like once we go through them, I feel like it's pretty straightforward. One thing to note about the estimate for repairs, the FAR contract is not clear as to who should be getting those estimates after the storm passes. So we know that our standard FAR contract for normal repairs, buyer will submit a list of defective items, seller will get the estimate, and the parties will proceed into the terms of the standard FAR contract as to whether the seller has a duty to remediate or not. Here, under the current FAR contract, it is not clear who's responsible for doing the post-storm inspection and obtaining those estimates, but my best advice is that the parties work together. Everyone has the same goal, especially if you're a transaction broker. Everyone has the same goal of making sure the transaction closes smoothly. So my best advice would be that everybody work together. So if the seller, if it's safe to provide access after the storm passes, so that the buyer, listing agent, contractor can view the property, get an assessment of any damage to the property, and then get the estimate. My strong suggestion would be the listing agent allow access sooner rather than later. What you don't want to do is wait until as a listing agent, force the buyer to wait until the day before closing, the day of closing, to do their walkthrough inspection, and then discover that there is significant damage to the property, and then the deal may end up blowing up on the closing date. And also, if there is some significant damage to the property, of course, the seller should want those issues to be identified so that the seller can remediate them. If not for this purchaser, then for a subsequent purchaser. And of course, they're going to want to get their insurance adjuster out to visit the property as well. So we know under our hypothetical, if there's significant damage, then our seller's only on the hook for 1.5% of the purchase price, and the buyer can either accept the property as is with the $6,000 worth of restoration or terminate the contract. All right, some lessons from Hurricane Ian. Number one on the list is patience, although I do think that this is the lesson that I am put on this earth to learn every year. So patience between the parties, patience with the insurance providers, patience with your lenders, with your closing agents. Again, going through a storm is a traumatic event. It is not something, that perhaps our clients who are living out of state particularly understand unless they've been through it. So we are hoping that they will demonstrate patience, and we will do our best to demonstrate patience with them as well. When we have buyers who were under contract during hurricane season, I think this actually will say this outside of hurricane season as well. Buyers should be looking into getting homeowners insurance and flood insurance at the very beginning of the transaction. Do it within the due diligence period. I know throughout the state of Florida, most folks use the FARBAR as is contract, which gives their buyer the right to back out of the contract for any reason. Make sure that they're able to get homeowners insurance and flood insurance at a reasonable rate during that due diligence period. And don't let your buyers, whether it's cash or a finance transaction, don't let them wait until the very last minute to bind their insurance policy. Again, as I mentioned before, there were some sellers' attorneys who thought that they could force a buyer to proceed with the closing when homeowners insurance wasn't available through no fault of the buyer's own, but maybe they're a week before closing and there's a moratorium on the issuance of homeowners insurance policies. If you're a cash buyer and you think there's no issue with waiting until a week before closing to be able to bind your homeowners insurance, I strongly believe that buyers can use that force majeure provision because there's no requirement that the buyer has to be a finance transaction or a finance contingent transaction in order to need homeowners insurance or flood insurance to be able to use that force majeure provision to extend the closing date. Some reasonable sellers will disagree, but until the contract requires, forces the buyer to get financing and waive the financing contingency to use that force majeure provision regarding homeowners insurance, flood insurance, I stand my ground. All right, sellers, keep your homeowners insurance policies and your flood insurance policy in place until closing and disbursement, until the transaction has actually closed. If you've got a seller who thinks the transaction is closing in our example on September 30th and they cancel their homeowners insurance policy on September 25th in advance, they contact the homeowners insurance provider and say, listen, I'm going to close on September 30th. Please stop my policy as of September 30th. And the transaction doesn't actually close until October 15th. Again, you're going 15 days without the property being protected. So make sure that you're keeping your insurance policies in place until closing and disbursement. I think that is also good advice inside and outside of hurricane season. Post-storm inspections, talked about this a little bit when we talked about risk of loss. Be reasonable. Make sure you're allowing your buyer and your buyer's agent access to the property when it's safe to do so, when utilities are available, when the property can be safely assessed. Again, the estimates for restoration, it's unclear currently in the contract as to who is obtaining those estimates, but collaboration is key when you're working with the other agent. Again, I think it's a benefit to the seller to have someone into the property to evaluate the damage. And of course, it's certainly a benefit to the buyer to be able to evaluate whether they're going to continue with the purchase if there's some significant damage that exceeds that risk of loss. And our loan closings, y'all, if you're closing during hurricane season, just be aware if there is a storm that passes through, the lender may require reinspection or reappraisal of the property after the storm. Our contract doesn't deal with that directly, but just know that that is a likelihood after a storm passes. Also, I didn't put this is related to our loan closings. If you have a seller who has a subsequent transaction, so your seller is selling in Florida, they're buying in North Carolina, have the conversation with them. If they're selling during hurricane season, there is a possibility that transaction will not close on time. And unless they have some sort of contingency in their purchase and their subsequent transaction, whether it's somewhere else in Florida or North Carolina or whatever, they may be putting their deposit at risk unnecessarily in their subsequent transaction. So again, just something to be aware of when you're doing a final closing for your sellers during hurricane season, whether or not there is a lender involved, that transaction may be delayed. Something to note regarding the condo common elements, this is a point of discussion. I don't have a clear answer for you, but this is a point of discussion. So our FARBAR Rider A, which will be revised this year because that is a revision year, just note in paragraph 9, it indicates that the rights and obligations under paragraph 11, which is the maintenance, and 12, which is inspection items, to maintain these items is limited to the seller's individual condominium unit, and unless the seller is otherwise responsible, doesn't extend to the other common elements, limited common elements, and other parts of the condo property. Meaning, if hurricane causes damage within the unit of the seller, then the seller would be responsible for the restoration of the, within the four walls of that condominium unit, or whatever it is that the seller is required to maintain pursuant to the declaration of condominium. Seller's not necessarily obligated to maintain those common elements. So if the common areas or the pools are destroyed during a casualty event, it doesn't mean necessarily, the litigators are, I imagine, still fighting over this, it doesn't necessarily mean that the seller has some sort of duty to restore those common elements, to restore the pool areas. What I point out, though, is the risk of loss provision is not referenced in this condo rider here. So just something to think about. There could be some significant damage to the common elements, minimal damage to the interior of the unit. And there have been situations where a buyer felt forced to close a transaction because the individual unit itself was fine, but the common elements were completely destroyed. I'd be curious to see how those cases are proceeding, because there are some that happened during Hurricane Ian, but it's just something to be aware of when we're talking to our customers. Generally, our seller only has the obligation to maintain the condo unit itself and not maintain the common elements, because those are the responsibility of the association. And I've got some resources here. So what our boards and brokerages need to do for a hurricane, use a good Florida Realtors resources, protect your technology. We've got some FEMA assistance when I send out the slides. These are clickable links, so you're welcome to use them when you're putting together your checklist for your consumers. We've got the Florida Realtors Disaster Relief Fund, the American Red Cross, and that is all I've got on the hurricane stuff. I feel like that was a lot of information in a really rapid fire succession, but as Kristen mentioned, we are doing our buyer broker mastermind again in 2 weeks, our regularly scheduled programming on April 9th. It's the second Tuesday of the month by Zoom at 10 a.m. If you have questions as we're getting closer to that date, and you want to make sure that we are addressing your questions during our presentation, and this is an update to our buyer broker mastermind post NAR settlement proposal. Send us your questions to info@getclosedgetpaid.com, but we will update our buyer broker agreement presentation. We'll include some of the updates from the that we think would be a good idea to include in your practice as a result of those proposed settlements. And if you have any questions, let us know. Kristen, you got any questions for me?
No, I just wanted to say thank you for your great hurricane presentation. We will have the update soon on for April 9th. We expect we'll probably need a second one update once the MLS rules and NAR policies come out, which is expected before mid-July. So when before mid-July is to be determined, but we will, if needed, we will schedule another one after April and make sure you guys constantly get the information you need on that subject.
Cool. I appreciate it. Awesome. All right, guys, thank you so much for your time. And thank you, Eric. Thanks, Melissa. Thanks for joining us. And as always, if you miss our presentations live, you are welcome to see them on our YouTube page. And we also have them hosted on our law firm website. So reach out to us if you have any questions. Thank you.
Yeah.